Thank you. Please be seated. Good morning. This is the time set for oral argument in 1 CV 160366 Walker v. U-Haul International. Counsel, each side is allotted 20 minutes for your argument. Appellant will have to reserve a portion of rebuttal if you choose to do so. If you do that, please keep track of the time at the podium clock for any rebuttal you would like to take advantage of. Out of respect for counsel, I ask that those in attendance please make sure your cell phones are off or on vibrate. Counsel, we have read the briefs, conference this case this morning. We encourage you to keep that in mind as you present your oral argument. Please be also reminded that we're recording these proceedings. They'll be posted to YouTube in due time. So before you begin your argument, please state your name and the party that you represent. With that, counsel for the appellant, you may proceed.
Thank you, Your Honor. Good morning. May it please the Court. My name is David Abney. I'm here today with my co-counsel, Paul Tyson. I'm not here today to argue that U-Haul did anything particularly wrong, but I'm here to argue that there were genuine issues of material fact that a jury could decide that U-Haul did a great deal wrong, not trying to prove the case in chief, simply to get back into court and allow the jury to do its job of resolving the disputed issues of fact. What happened here today is an interesting system. U-Haul arranged for various ways that internet business would be taken from the service providers. Fairly simple systems and sometimes fairly sophisticated. The basic thing would be if you would go to U-Haul, you should go to Google like we all do and say, I want to move from my home in Mesa on September 30, and I want a good moving company in my area. A screen would come up that would have a bunch of advertisements on it and listings and information. And one of those would be, for instance, something, say, Diamondback Movers, describing the business, giving an address, information, and a phone number. And then you call the phone number, but you don't go to Diamondback Movers. You go to a U-Haul call center. And at the U-Haul call center, they may say something to the effect, this is moving help or something to that effect. And from there on, they will get you connected with a moving business that can handle your business. You could arrange everything there on the phone, arrange for the credit card payment, and at that point, the money goes 15% to U-Haul and 85% to the business. But it doesn't go to Diamondback Movers; it goes to some other business.
But how is that a violation of the statute if at the time the identifying information is requested, there's no question regarding who's asking for the information?
Well, you start at the very beginning because there's been a use of the Internet that has solicited or induced action, and eventually the identifying information is provided. And you induced it by representing indirectly, at least, that you were that company. It had the company name there with the phone number, and naturally you would think if you have the company name there with the phone number, you're calling the company.
But let's say it goes to, you think that when you make the phone call, but the person answering the phone says, that company is out of business. I am ABC Corporation. Would you like to do business with me? If you do, please provide your credit card information, and I'll provide that service. Is that a violation of the statute?
Well, yes, because what you have done was you represented originally that you were Diamondback Movers, and then you wind up, instead of with Diamondback Movers,
but the representation wasn't to get you to provide identifying information, which is how I can read that statute. You're inducing someone to provide identifying information by implying that I have the authority or approval of someone else. And my hypothetical to you is where I'm telling you that company no longer exists. I have absolutely nothing to do with them. I am ABC Corporation, and I want your identifying information. Why would that violate this statute?
I believe that's probably the worst situation from my point of view, where they actually say, holy smokes, we're so sorry, something effective. No, that company's out of business and we're somebody else.
Well, and I'm telling you that they're really not out of business, so I've been misleading, and you may have some kind of cause of action, but it doesn't seem to fit within 447202. It seems different. I've made clear who I am when I ask you for your information.
If you go to that extreme, if the facts say that extreme situation, then you are perilously close to cutting any connection with the statute and any liability.
Are you suggesting that the facts here, because I'm just looking at Judge Witten's ruling, he's saying the evidence is clear that the websites didn't identify the plaintiffs in any way at the time they're asking for information. Are you suggesting that that's not accurate, or?
That's not accurate, no. And what he was describing is not the plain and simple situation, the usual situation. He's describing a situation where there's a web page and a hyperlink to another web page. But what gets you there to the ultimate page where you provide the identifying information is a misrepresentation at the very beginning. Now, the hypothetical that you posited probably pushes us outside of the statute because it's so emphatic that we're definitely not Diamondback movers. But that's not the bulk of the situations. That's not what we're worried about here. We're worried about situations where you wind up, through use of the phone number, for instance, at a U-Haul call center and never realize that it's not Diamondback movers, and they slide you then into somebody else who does the business. U-Haul gets 15%, and that other business gets 85%, and Diamondback gets nothing. So I mean, there can be an extreme situation like you suggest. But and if that's the case, then I don't think the trier of fact is going to take very long in deciding in those particular instances there's not going to be liability. But we're talking about instances like the one I described at the beginning where there would be liability because you have indirectly represented on that page where there's a phone number that you are indeed Diamondback movers.
So is your position that the statute is clear, it applies to more than phishing, and the issue for you is my client wanted the opportunity to prove to a jury that my facts meet this definition.
Yes, Your Honor. The phishing thing is a very troubling problem on a couple levels. One is there's nothing about phishing in the statute. It's not in the title, it's not in the text. The other thing is that if you actually delve into phishing, I don't know if I'm mixing metaphors here, but if you delve into the phishing issue itself, there's a number of contemporary dictionaries that say it's not just using emails to trick people. Like you get these emails from the Nigerian prince who wants help with his oil problem, but you're also just using the web or using the internet. That's another definition of phishing. Which really, this statute is incredibly broad at the beginning because it talks not only about web pages or electronic mail, the traditional sort of phishing with electronic mail, but also otherwise using the internet. Very broad.
So, I apologize if I'm repeating myself. Is your position that the statute is clear, what it applies to, what it doesn't apply to, and Judge Witten was wrong to find it was ambiguous and go on to the record of history to find that it only applies to phishing?
Oh, it doesn't. I don't see any interpretation of the statute that leads you to say that it could only apply to phishing, especially since the tripartite beginning, web page, electronic mail, or otherwise using the internet. If it
I'm sorry. How far removed can it be if you've been on the internet? There was an advertisement for Diamondback movers or someone, but you're 8 steps removed, and no one has claimed it during those 8 steps that they have anything to do with Diamondback movers. And by the time you actually ask for identifying information, it should be abundantly clear to anyone in the universe that you're providing the information to someone other than Diamondback movers. And you're saying that any use of the internet, there was some use of the internet 8 steps ago, but we've made it abundantly clear since then. Are you saying that applies here?
No, I'm not that foolish to answer a question like that any way other than no. But there's going to be jurors, there's going to be situations at the trial, I hope there is a trial, where the defense will posit, in this particular instance, A, B, C, D happened, and it's your situation. And the jurors will say, no, there's no connection. There has to be some sort of causal connection. There's not going to be liability. But there's going to be the other situations where it's a much shallower introduction of the internet. There's not 8 steps, and you are clearly being deceived, misled, misrepresented, however you want to look at that. That's why this thing really belongs with a jury. You can posit hypotheticals that go to the far extreme and kick you out of the statute. But then again, you can posit situations like the ones where the evidence suggests happen that are far closer and don't involve so many steps, and where there would be liability. But it's got to be for the trier of fact to resolve these things.
Were there motions for summary judgment on both sides asking for a ruling on the
There were a motion
on the statute?
There was a motion for judgment on the pleadings by our side. There was motions for
But
summary judgment.
you would
on the
agree
side.
then that you would not be entitled to a
No,
summary judgment on that?
absolutely not. This thing is a factual nightmare. It's going to be hard to prove damages. It's going to be hard to prove causation. But these things can be proved. You get a good forensic expert.
So what was the basis for the motion for judgment on the pleadings then, if it's going to that statute?
A hopeful stab to try to get some sort of ruling in favor of the plaintiffs. I didn't write it, and I don't think it had a chance of success.
Whether it's if everybody agreed that the facts are clear, that. But you're suggesting that the facts are not clear. So,
the facts are a morass, and rightly so. This is a jury problem. What did U-Haul actually do? What's the connection between eMove and U-Haul? How did the moving center operate? How did people get from point A when they started out on the internet at Google or Yahoo or Yellow Pages, and then get over to the point where the business is not going to the service providers, but it's going to the benefit of U-Haul? There's a whole bunch of factual issues here that have to be resolved by the jury.
Do you take issue at all with the example that Judge Whitten uses in his minute entry?
The web page example?
I think it's a furniture manufacturer example.
If you just go somewhere, actually I think there's an email marketing campaign misusing the name, but you go somewhere, you go to a I may just be making this up, but you go to a convention center, you've been told, let's say you haven't even used the internet, but you got something in the mail that says vendor B is going to be in stall 31. And he will sell you this product. You get to stall 31, and it's vendor A. And there's vendor B is nowhere to be found. Vendor A says, I'm vendor A. B's not here. He's never worked here.
Well, if something that extreme happens, the jury will deal with it. But we're not talking about things that extreme. We're not hoping to get the whole universe of things that U-Haul may have done that were deceptive, misleading, or whatnot. But the ones that make sense, where there is a causal connection, reasonable jurors will be able to figure this out.
And what's the best evidence that you have that U-Haul misrepresented? And I apologize if you think that's already covered by what you've explained, but just the best evidence that they were misrepresenting who they were to get the identifying information.
I think the example I started off with is the cleanest and clearest. You put in information at Google, you wind up at a page that gives you the name of Diamondback Moving, description of the services, address, and the phone number. You're thinking, well, this is great. You call the phone number, they say something like, Moving Help, how can we help you? And eventually fairly soon, you wind up, well, Diamondback's busy or Diamondback's unavailable, and we're going to have somebody else do it. Business that would have gone to Diamondback if its number had been put in there winds up at U-Haul. Pretty slick in a way when you think about it. And it's very straightforward. I don't think a jury was going to have a huge problem with those sorts of situations. Now, you got to prove it all. You've got to sort of reconstruct how things were on the internet. You've got to reconstruct the business flow, the loss of business. You're going to have some interesting forensic testimony on top of everything else, but it's provable.
And this was this a situation where U-Haul put the information on the website initially, and they're charging the service providers for this service, and then they're no longer doing it, but the website's still there and it just hasn't been taken down? Or is this something that you would get to independently that, say, Diamondback or some other service provider independently has an internet presence, and if you Google their name, you get to U-Haul's website?
It's a carryover. I mean, they had an original relationship with U-Haul, and gradually those relationships stopped, but U-Haul kept on.
Oh, put the information on the...
Right.
Okay, so in your view, they were required to immediately delete it?
Yes.
Once they...
Well, delete it and stop using it. When people call the number, they should say, you know, something that they just deactivate the phone number would be the easiest thing to do. But what they did was wrong.
At the top of page 3 of Judge Witten's main entry, it says, while this practice may very well be unfair competition, it would not violate the statute because the original of this mail message did not solicit, request, or induce another person to provide identifying information. So, so when you put it into Google and you go to that website, that's not, you know, you're not giving your identifying information there.
Not at that point.
So the judge's view, I take it, is that's why your facts don't meet the statute.
Right. That is his opinion. It has to be a sort of not only direct but immediate kind of thing. But the statute, I think, is one that also deals with indirect effects. And so the notion that you have to have the immediate giving of the identifying information right at the start, I do not think that is something that is, well, let me back up that sentence. I think that the way the statute can operate and impose liability is a little bit longer than that. You can have an indirect effect.
Well, and Judge Witten talks about, in that sentence that Judge Howe just read, it says it might be unfair competition in violation of the statute because the original electronic message. But nowhere in the statute does it say it has to be in the original message.
That's correct.
Is that correct?
That is my point, Your Honor.
And that's that it could be downstream that you get this information and
Yes.
still violate 7202.
Right. And
the question that follows from that is, so is how attenuated does it can you get before the chain is just too long?
well, sure. I mean, absolutely. I think in any sort of legal situation, you can go to the point where it's just absurd. But we're not talking about and trying to impose liability to the point of absurdity at all. We're simply saying that the jury should have the right to see if the evidence is satisfactory that there is indeed a clear causal connection and liability. This is a jury case, Your Honor, and Your Honor. Your Honor. If I may reserve my time.
Thank you, counsel.
Thank you.
Counsel for the appellee, go ahead.
It's a little small, but can you all?
Not really.
All right. Well,
Is this part of the record, counsel?
It is. It is. It was used in the oral argument for Judge Witten, and it was one of the exhibits to the summary judgment, so it's not new. May I proceed?
Yes.
Your Honor, thank you. Patrick Fowler for defendants appellees, eMove Inc. and U-Haul, along with my co-counsel Simone Reyes. Thank you for taking the time to consider oral argument today. Let me, our position obviously is that the trial court correctly interpreted the statute and found that the alleged conduct the plaintiffs have alleged against eMove and U-Haul did not violate the statute.
Is it your position that Judge Witten found this statute to be ambiguous and that's why he delved into the legislative history?
Yes, he looked at the legislative history because the parties, even the plaintiffs, had a disagreement internally as to how to interpret the statute. In terms
But was
of,
was that sum and substance? Was that the bedrock of his analysis, that it was ambiguous, and that formed the basis for his decision?
well, I don't know that it was the bedrock, but in order to give proper application of the statute, it was important. It was, I think, Judge Whitten found that it was necessary to look at the legislative history to understand what it was that the legislature intended in creating this, passing the statute.
But you would agree with me that you only go into that analysis after you find a statute to be ambiguous, correct?
That's true.
Okay.
That's true.
But on page 3 of the mandatory, the sentence after the sentence I read earlier said this conclusion is supported by a review of the legislative history. So it sounds like he's already concluded, and this is the legislative history is an additional support.
That's true.
For his earlier conclusion.
That's true. I mean, at the end of it, Judge Whitten analyzed this statute, applied it to the facts, the undisputed facts in the case, and found that the statute did not, or that the conduct alleged by the plaintiffs against the defendants did not violate that statute. You looked at the legislative history because there were aspects of the statute that are ambiguous, and used that legislative history, as he said, to support the conclusion that the conduct alleged against defendants did not violate the statute. I mean, it's undisputed that the defendants did not solicit or request any identifying information from any web page or internet page that had the plaintiffs, any of the plaintiffs' information on it. And if I could, in terms of the plaintiff's recitation of the history was generally accurate, but it was eMove, which is a subsidiary of U-Haul and a separate corporation, which is the one that set up this moving help marketplace in 2002. The idea was to match people who needed to move with companies that provided moving services. And so it created this marketplace. And what happened was that the companies that participated as service providers in the marketplace over the years since the marketplace was created in 2002 were encouraged to create landing pages within the Moving Help Marketplace domain, or movinghelp.com. And the analogy I would use in terms of the structure of that is if you go to a law firm website and it has a list for the attorneys, and each attorney has a page in there where it has their biographical information. Same sort of setup. Each of those pages, the landing pages for, be it for an attorney at a law firm or one of these service providers who was participating in the program, had its own web address. And so people would be able to access those web pages through the internet. In 2011, to try to increase the traffic to the service providers and to the Moving Help Marketplace, eMove created this test program where they sent to websites, search engines like Google and Yahoo and Bing, a set of information for the service providers that the service providers had provided on their landing pages. The idea was you have these links put on Google or Yahoo or whatnot that someone could click on. If they type in moving services Phoenix, and you click that on, you might go a link that says Diamondback Movers - Moving Help may pop up. Someone would click that link. It would take them to, if Diamondback Movers was still an active affiliate in the marketplace, take them to the Diamondback Movers landing page.
And in this instance, Diamondback Movers were no longer an active.
That is true. That is true. And the clerical error that was made by eMove was it should have removed the data feeds that it sent to Google and Yahoo and Bing and whatnot.
But it failed to do that.
Correct. It should have, and it didn't do that. And so there were these links that were populated. That some of them had the names of the plaintiffs on them. So if someone clicked that on after these service providers were terminated, the 14 plaintiffs, it would not take them to a landing page that has Diamondback Movers website. Instead, it would take them to this generic movinghelp.com landing page, which allows someone to go ahead and to try to find another service provider. But this is the landing page that someone would have gone to had they clicked on the a link that had one of the plaintiffs' names on it affiliated with Moving Help. Nowhere on this, and this was something that I think the trial court, Judge Whitten relied upon, is that nowhere on this does it have any information about the plaintiffs. It does not represent to be any of the plaintiffs. It makes it clear that it's the Moving Help marketplace.
If someone had just Googled Diamondback Movers, do they get to that webpage?
No. If they had just Googled Diamondback Movers, they very well may have gotten the actual diamondbackmovers.com website. And if they had done that, they would go directly to Diamondback Movers.
But conversely, they could have gotten to Diamondback Movers, this older website, I don't know the terminology, that had Diamondback Movers, clicked on that, and then got that website, correct?
Yes, yeah. If they go to Google and they type in Diamondback Movers, I suppose it was possible that they could have then gotten the search results that has all the links on it, and one of them could have been Diamondback Movers Moving Help. And if they had clicked that on once Diamondback Movers was terminated, they would get this. They would go to this webpage, which says movinghelp.com. It does not say Diamondback Movers. And if the potential customer then filled in all the information necessary to set up a reservation, where do you want to start, where do you want to end, the day of the start, the day you want to finish the move, and some other features, they would then be given a list of several providers who fit those search terms, if you will, and they could decide based on price or whatnot.
But one of them would not have been Diamondback
One of them would not be Diamondback Movers because they were no longer part.
So if the person wants Diamondback Movers, isn't it going to, and does it think, could the customer believe that they're still using Diamondback Movers or its successors?
I think Judge Whitten found that there was nothing on this web page or the web pages that customers would flow to from here that had any of the plaintiffs' identifying information.
Well, the one that they got there from had Diamondback Movers. So,
correct.
I mean, they could have thought, as I think Judge Howe was leading to, they could have got Diamondback Movers thinking they're going to get that, click on that, get them, still think they're dealing with Diamondback Movers. Isn't that possible?
Well, I suppose it's possible. There's no evidence in the record that ever occurred. So we're talking about a hypothetical. And,
but we're talking about the summary judgment stage. They haven't been able to prove that.
Well, but there's no evidence that ever occurred. And while that may be a different kind of business tort, the use of Diamondback Movers' name on a Google link somewhere, that's not a violation of this statute. That's not what this statute prohibits.
How?
Because, well, for a number of reasons. First of all, it doesn't, this statute, the plain language of it says, a person shall not by means of a webpage, et cetera, solicit, request, or take any action to induce.
Doesn't it take any action? Can't you read that pretty broadly? You've taken some action, and I tend to agree that this doesn't look like a very good case under the statute, but I can read it as you've taken some action. You've misrepresented that you're affiliated with Diamondback Movers or one of the service providers. I've taken some action. Why doesn't that leave it as a jury question?
And that's a good question. But simply, the plaintiffs made that argument down below where they said, well, and they essentially seemed to concede that the defendants were not misrepresenting themselves as one of the plaintiffs, but they were inferring a business relationship. Well, inferring a business relationship is not a violation of the statute. It's that you are representing.
And can't you read the statute to say that? Any action to induce someone.
Directly or by implication. And I think Judge Whitten in his minute entry only talked about the direct solicitation. He didn't address, which I believe appellants have argued on brief, that this was done by implication. So how do you get by the implication part of that statute, counsel?
The idea is that I think that the purpose of this statute was where you have someone who is, so you have somebody who is representing that they are someone else, so that when a customer does business, they don't think they're doing business with you, they think they're doing business with someone else. And the fact is that when someone if someone clicked on a link that had Diamondback Movers' name on it, it took them to this thing called movinghelp.com. You know, people are savvy enough when they are navigating the internet now. If well,
maybe this is the web page that Diamondback Movers created.
Well, if someone simply typed in moving services Phoenix, and one of the links that came up was Diamondback Movers. First of all, there's no indication that they were specifically looking for Diamondback Movers. They're looking for moving services. And so if they click on a link that happens to have Diamondback Movers' name on it, and it takes them to this web page that says movinghelp.com, and they end up knowing that who they're contracting with is ABC Moving, because that's one of the service providers that meets the search criteria. They know that they are not dealing with Diamondback Movers. They are giving their money to Moving Help to facilitate a transaction between them and ABC Moving. No consumers are losing money. They're not being defrauded out of their credit card numbers, anything like that. They understand that based on the plain language of the websites, that they are not dealing with any of the plaintiffs when they click these links on, or when they call the call center. There's no dispute here that when someone would call the call center using one of these phone numbers that were assigned, that anyone at the call center represented themselves to be one of the plaintiffs in this case. They would identify themselves as being Moving Help, and then they would basically go through the same process of giving the start date, end date, the location of start, where you end, and then be given a list of service providers over the phone to select from. So
if someone said it says Diamondback Moving, they think, no, we're a clearing house.
Right.
Is that what they would say?
Well, I don't know. They would say if someone called up, for example, someone called up and said, I'd like to hire Diamondback Movers, the person at the call center would say that company's not available because it wouldn't have been on the list of service providers. So there's no way that anyone, and I think as Judge...
But isn't that a little bit misleading, though? Or that they're not available through me. I'm asking you for Diamondback Movers, and if you suggest that they're out of business when they're really not, aren't you inducing someone to go in a different direction?
Well, I think they're answering truthfully that they're not part of this program. I don't know that they would say that they're out of business.
You said they're not available.
They're not available through this program.
That's not telling the whole truth. We have to tell the truth, the whole truth, and nothing but the truth.
Well, is that part of the record, exactly what they tell them when they...
Yes. I mean, there are a number of plaintiffs, individual plaintiffs, who called the call center. And I think one or two of them made audio recordings of it, and that's part of the summary judgment record, that none of them, that they all conceded that no one at the call center ever said, this is Diamondback Movers, can I help you? Because the people at the call center wouldn't know the source of the phone number, whether it was assigned to Diamondback Movers or ABC Moving.
What did they say about Diamondback Movers when they answered the...
I think, as I'm trying to recall, I think it was they are, I don't know if it was they are not available or they're not on my list of people. If someone wanted to hire Diamondback Movers, they could type in the diamondbackmovers.com on Google or Bing or whatever and find the website that says Diamondback Movers, if that was that important to them. But the plaintiffs have not offered any evidence in this record that there was a single person out there who typed in diamondbackmovers.com and was sent to Moving Help.
But someone could have typed in just Diamondback Movers without the .com, and you just get a list of Google options, and one of them sends you to Moving Help.
Yeah, that would be a possibility, yes, but there's no evidence in the record that anyone actually did it. We're talking about, a hypothetical possibility, but the plaintiffs never, and that was part
How would they know that, though? They would have to go find all the customers who've called. Why isn't that a jury question? That we know that this is something that could happen. You can type in Diamondback Movers, it directs me to this website. I agree it seems pretty attenuated, but couldn't a juror say you had an obligation to do more if you're going to use the internet? You had an obligation to do more than, you had an obligation to remove them from that website or tell them, no, this is how you reach Diamondback Movers.
Well, I think we get into the realm of speculation, though, in terms of what could possibly happen. And there's no evidence, certainly from they had an expert give a deposition. He never gave testimony that he saw any indication that had happened in the work that he did, looking at
Didn't they
search
provide
engine
evidence of just kind of the
optimization.
drop-off in calls that came in?
One of the plaintiffs, I think, alleged that there was a drop-off. Of course, this was still during the Great Recession, but their expert, who focused only on the search engine optimization, didn't make any efforts to find out what sort of data there was prior to this test program occurring in terms of the number of hits that Diamondback Movers had on its website, et cetera. So we had no baseline to then assess what potential objective impact there was between before and after this test program. So, one of the things also that and I've just got a little bit of time left, but one of the things that the plaintiffs also have not provided in this case, and Judge Whitten didn't address it in his ruling, was the lack of evidence of adverse effect. That is one of the things that they have to establish in order to have standing to sue under this statute. And we spent a considerable amount of time deposing essentially every plaintiff, exchanging lots of documents, electronic and hard copy documents, and asking the plaintiffs to substantiate the claim.
But that's not something Judge Whitten ruled on, you're saying? So
it was not part of what he based, but it is part of the record that was before him and would be a basis to uphold the summary judgment.
How would it be a basis? We would have to draw the conclusion ourselves?
Well,
You're saying there's just
there is
zero evidence?
there is evidence in the plaintiffs failed to address, that failed to offer evidence to prove that they were adversely affected by
Is that in
this.
your briefing?
It is.
Okay.
It is.
Well, counsel, is part of your argument that because that website doesn't ask for the identifying information that the ticket requires, that's the main reason why the statute doesn't apply?
This statute was intended to address the issue of phishing. And the issue of phishing is,
Well, and I understand that, but we only look at the phishing aspect of this if we find the statute is unclear. So you believe the statute is ambiguous, that it could apply to your client's conduct were it not for the legislative history?
no, this statute, regardless of how it's, I don't think under any reasonable interpretation, and certainly not given the thorough analysis that Judge Whitten gave, the defendant's alleged behavior does not violate this statute. I mean, it certainly was. This statute wasn't intended to address the activity that defendants were engaged in here, which is a legitimate business practice. Whether it might run afoul of competition laws or trademark is not this case. The plaintiffs actually had, at least one of the plaintiffs had all of those claims in initially and dismissed all of them to focus just on 7202. And they put all their eggs in that basket, and we spent a considerable amount of time briefing it. Judge Whitten we had hours of oral argument before him, and I think his analysis is the correct one, finding that the behavior, the conduct alleged here does not violate this statute. So we would ask that the court affirm Judge Whitten's judgment.
Thank you, counsel.
I thought at one point early on that my colleague talked about clerical error as a defense. If the jury decides there has been some sort of clerical error, I think that probably would be a defense, but that's something for the jury to decide. The way the system was set up and maintained for so long, it doesn't look like any sort of error, clerical or otherwise. By implication, is very broad. by using the internet, otherwise using the internet, very broad. This whole statute is incredibly broad, not just limited to phishing.
Why were all of the other claims dismissed? He's suggesting,
Oh, you mean-
counsel's suggesting that your clients decided to only go under the statute and not pursue any other type of remedy?
Pardon me for saying this, I don't know. I can assume that they thought this was the clearest statute to deal with, and it is in many ways. It's almost a strict liability sort of thing in some aspects, and it's very, very broad. If I were a lawyer handling this, I think I would have put the eggs in one basket and said, this is a good statute, let's use this statute. The other ones can be very confusing, but this one isn't. There was some discussion of adverse effect, and I addressed it in my reply brief at pages 16 and 17.
But that wasn't part of the court's ruling.
Well, it wasn't part of the ruling. The only reason I addressed it was raised in the answering brief, and I try to address everything that's in the answering brief, even if it doesn't really, to me, matter. But adverse effect is not truly defined. It could be very broad. Confusion in your customers, damage to business reputation, having to bring the lawsuit at all. There can be a whole number of things.
And that
including-
wasn't the basis in any way of Judge Witten's ruling below,
No,
correct?
no, Your Honor. There was a drop in business, and I put it. It's in the. If you care to look at it, it was pages 31 and 32 of the opening brief. There's a discussion of Diamondback, what happened to their business. It wasn't during the Great Recession. I think it was 2008 or so, somewhere in there. This is a couple years later. But anyway, that's a red herring. Your Honors, this is a case that really needs to go to the jury. It may not be the greatest case in the world, the strongest case, but then again, as discovery goes forward, it may turn out to be a crackerjack and really, really strong, and get somebody at U-Haul to turn state's evidence, as we say, and away you go. You never know. But there was some very interesting testimony already from U-Haul as to exactly how they set this up and incentives that they gave to their people to try to get the business in. The whole point of what was happening here was that the 15% commission would be going to U-Haul and the 85% would not be going to the service providers. That was the goal, and that was attained quite often with a disastrous effect for Diamondback and others. I have used my time. Thank you very much for your attention. I appreciate it. Thank you, Your
Thank you,
Honor.
counsel. I'd like to thank both counsel for your briefs and presentation here today. They're very well done. I do appreciate it. We'll take the matter under advisement and issue a written ruling in due course. We're now going to stand at recess. We're going to stay on the bench, allow the next case to set up at council table. Thank you.
Thank you, Your Honor.